My name is Anthony Goodall, Chair, distinguished members of the panel. I'm an attorney here in Austin, and I represent one of the larger providers of orthodontics care in the state of Texas. And I support House Bill 1536. We are confident that this bill will provide a much-needed protection for due process from abuses from the Office of Inspector General. To give you some history on my client's experience, maybe this is going to sound a little anecdotal, but to continue on the theme of Dr. Dunn's experience, my client was approached several years ago by a dental director of NHIC, the contractor for the state that monitored Medicaid distributions. And my client was urged to open offices in areas where there were shortages of Medicaid providers for orthodontic care. Over time, the practices were opened and children successfully treated from El Paso to Corpus Christi. Every attempt was made on my client's part to become the gold standard in how orthodontic services were to be provided under the Medicaid system. The practice had hired well-respected orthodontists who had been graduated from accredited orthodontic programs. As the year 2012 opened, my client was serving Medicaid patients in 6 locations in the state and was scheduled to open the 7th within months. On February 13th last year, while I was at my client's office, the phone rang at 9 a.m. Within 25 minutes, the Office of Inspector General investigators had arrived at each of the offices throughout the state, demanding records, requesting interviews, and otherwise disrupting the patient flow for that day and that week and for weeks to come. OIG had issued its demand for records and showed little sympathy for the magnitude of the task or demands placed on the practice. By Friday that week, February 17th, OIG issued a letter placing my client on 100% payment hold due to missing a few of the patient's cast models for their mouths. In the days that followed, OIG engaged the services of a doctor as its expert who had never practiced Medicaid or ever filled out an HLD score sheet before. He became the OIG's expert on whether this practice had been submitting improper Medicaid benefit applications. On February 29th that year, OIG issued an amended payment hold letter stating that in addition to the missing physical models, the expert took issue with the HLD scores submitted to TMHP. On behalf of our client, we timely requested an expedited payment hold hearing to contest the validity of the payment hold. That expedited hearing has been scheduled for August 19th of this year, 1.5 years after the 100% payment hold was imposed. To continue treating the thousands of children in care, we requested an emergency meeting with Commissioner Seuss to ask for emergency funds. Mr. Seuss turned the matter back to the OIG, who scheduled the meeting for April 24th last year. We were told in the meeting, A, the provider was under suspicion of fraud and there was no way further funds would be released. B, only 3% of the patients that received prior approval from TMHP should have been approved, and the OIG reviewed it, the blame of the provider. C, if the provider didn't continue treating the children despite the payment hold, OIG was working with the dental board and would see that the provider lost his license to practice. D, OIG wanted to recoup around $48 million from the practice. And E, if we didn't resolve this matter immediately, the practice could expect some adverse publicity in our service area, which it did. That meeting wasn't quite what we had expected. House Bill 1536 does not resolve the abuse of power by OIG in indiscriminately imposing payment holds. Clearly, there is no impartial review of the application of the credible allegation of fraud standard. Clearly, there is no due process available to oppose a payment hold. Clearly, there is no such thing as an expedited hearing. Clearly, informal conferences are a sham. House Bill 1536 will not restore losses of reputation, the ruination of practices. It won't take care of the thousands of children who have gone untreated or restore the numerous of jobs to those who lost them. Clearly, House Bill 1536 may not prevent OIG from playing judge, jury, and executioner anymore at the payment hold stage, but at least, if it is enacted, providers can be assured a higher standard of fairness and due process during the overpayment hearings. Appreciate your time. I'm open to questions.
Commissioner Doug?
So let me get this straight. Your client was told that if they did not cooperate that they were going to receive negative attention in the area that,
yes,
that they practiced, which happened anyway, even though they cooperated.
Cooperated. The inference was pay the money. Settle the case, pay the money.
Okay. Thank you.